This one. Okay, got it. Okay, so the rent cap and just cause addendum, we talked about that recently when we talked about, I can't remember what, but something with leases. And again, this comes out with a brand new lease. If you go to CAR and you print a lease, it'll come out with this. But there's a box right here on the first page that you have to check. And we're going to go through the law and you're going to see how many times they say that you're only exempt if you have this, if you send this notice with this exact thing in it. They give you the language and everything in the statute. It's like the TDS. They tell you exactly what to say. And it's all here in this form. Again, it comes, this CAR has this form separately, and it also comes out with leases. If you get the form from a tenant who's already in possession, you need them to sign it. Otherwise, it's not going to be good anymore. It used to be when it first came out, you could just send it. But then after like August of 2020, you had to have it signed. So, and we're going to go through that. But this is the form. And if you don't do it, that's the problem. Okay.
So every tenant has to sign this new form. Is that right?
Box checked. It's I mean, it was new in 2020, but yes.
Oh.
And I know that nobody remembers this except for me, but this law came out in January of 2020.
You told us this before.
Right, a bunch of, right. We went over it a billion times.
Yes.
Then COVID hit.
So a lot of us did it.
So nothing stuck, right? It all went out the window because we had more restrictive COVID laws for the last 2 to 3 years. So now we are back to this, which is the law in the entire state, and it covers all rental property unless they're exempt, and we'll get to the exemption. Okay, so it's 2 parts. The first part is the just cause for eviction, and the second part is the rent control. So we're going to start with the just cause for eviction. Okay. Notwithstanding any other law, after a tenant has continuously and lawfully occupied a residential property for 12 months, the owner of the property shall not terminate the tenancy without just cause, which shall be stated in a written notice. If any additional adult tenants have been added to the lease before an existing tenant has lived there for 24 months, then the subdivision only applies if all of the tenants have continually, so we added a tenant. We became a tenant, we got married after a year, we added our wife as a tenant. All of the tenants have continuously and lawfully occupied the property for 12 months. So all of them have to have. So if you add one and they haven't been there 12 months, they don't count for this law. 1 or more tenants have continuously and lawfully occupied the property for 24 months. Okay, so 1 tenant only has to occupy it for 12 months. It's only if there's a second tenant that this 24-month rule comes in, a later added tenant. Okay, so just cause includes 2 types, the 2 things they consider just cause: at fault, and then they also have a just cause provision that's not at fault. So there are both of these have times when you can terminate a tenancy in the state of California, okay, if you're under this law. At fault, default in the payment of rent, so you can always terminate for default. A breach of a material term of the lease, as described in paragraph 3, which are, you know, a lot of terms. Violating a provision of the lease after being issued a written notice to correct. So you have to, same thing in rent, you have to give them a notice to correct. Let's just say that you, the landlord, wanted to go in and inspect the property because for something that is wrong with it, and you send them a notice that you'll be coming in to inspect, and they don't allow you to come in. That's a reason, that's a breach of a material term in your lease. If the standard lease does say that the landlord is allowed to come in. So if there's a term in the lease that, you know, maybe they're only allowed to have 2 cars on the premises. You know, all leases are different, and they've got 3. That'd be a breach. You can evict them for that, but you have to give them a 3-day notice to cure or quit. Okay, if the tenant's maintaining, committing, or permitting the maintenance or commission of a nuisance, and nuisance is, you know, where you're bothering. It's pretty much, it has a definition, but it's pretty much what you think. If you live in your unit, you're a nuisance to those around you. That's you can't do that. Okay, committing waste, that would be like wrecking it. Okay, the tenant had a written lease that terminated on or after January, okay, and after January 1st of 2020. So you had a lease that terminated on or after the day this law went into effect. And after a written request or demand from the owner, the tenant has refused to execute a written extension or renewal of the lease for an additional term or similar duration with similar provisions. Okay. So the tenant and we're pretty much done with this first one. That because in this one, it has to, the written lease that terminated on or after January 20th. We're way past that now. We're going to get to what happens if it was after. Okay, but you could terminated them then. Criminal activity by the tenant on the residential real property. Okay, so if they, they get caught for some criminal activity on your property, you can terminate it. Let's go back to this one. Okay, so if you have a tenant and they have a written lease for, let's say, a year, you signed it in May 1st of 2022, and it goes through April 30th of 2023. Okay, you can, if you're not subject to this law, you can evict them because the lease is up. You don't need to give notice. You don't need to do anything. If they don't move, you can just evict them. Your lease is up. If you're subject to the Tenant Protection Act, you can no longer do that. You have to offer them a new lease of similar duration. And it can obviously have the only rent increase will be what we're going to get to down here. But you can offer them a new lease. And if they won't sign a new lease, they had a year lease. If they won't sign another 1-year lease, then you can terminate their tenancy. But you have to offer them a chance to do that. Okay, assigning or subletting the premises in violation of tenant's lease. Okay, so they are going to, this is during COVID, we couldn't do this, but you can, if they assign it to someone else or sublet it without your written permission, then you can terminate their tenancy, the tenancy. The tenant's refusal to allow the owner to enter the property is authorized for health and safety. And, the tenant has to give a notice, the landlord has to give a notice. But if the tenant refuses to let the landlord in, then you can evict him. Using the premise for an unlawful purpose as described in paragraph 4. So it would be anything unlawful, obviously, if you were. The employee, agent, or licensee's failure to vacate after their termination as an employee, agent, or license, then you can terminate them too. So you have a manager that lives there, or you have a care person who lives there, you can terminate them. Okay, so this is the last one. When the tenant fails to deliver possession of the real property after providing the owner written notice that they were leaving. So I give you notice, I give you a 60-day notice, landlord, or a 30-day notice, I'll be out in 30 days, and then I refuse to, then I don't leave. Then you can terminate their tenancy for cause. Okay, so no fault, just cause. That means that you can still do this even though there's no fault involved. They're allowing these, okay, but it's not much. Intent to occupy the premises. Okay, so if you just bought a house and you intend to occupy it, you can go through this non-fault, which includes the owner's intent to occupy the premises. Okay, this is the one I don't get the difference between A and B really. Okay, so the next one is withdrawal of the residential real property from the rental market. If the owner is going to move in, aren't you withdrawing it from the rental market? How is that different from the owner moving in? The owner moving in seems very complicated when all you have to do is say you're taking it off the rental market. You're going to live there and not rent it, then you're taking it off the rental market, right? So I don't know. That's how I think. But anyway, again, this is the one. If you're selling your property, that we used for a long time during COVID, as I'm going to withdraw this from the rental market. But you have to then sell the property to someone who's going to live there. You can't sell it to an investor. Investor's going to rent it out, or your tenant finds out, they're going to come back and you're going to be in trouble. So, and tenants, they have lots of rights. So you don't want to be on the wrong side of an ex-tenant. So
Cindy.
Yeah, go ahead.
So my question is regarding letter B.
Mm-hmm.
Am I muted? Okay. Regarding letter B, is that maybe they're gonna make it as Airbnb or VRBO?
No, because that's the rental market, right? It's a short-term rental. You can't do that. You have to be taking it off. You have to say, I'm not going to rent this property out anymore.
Or maybe as a residential care facility for the elderly or developmentally disabled, the facility. That's
Yeah,
what I'm
that
just
would,
thinking of it as
yeah,
as
if
an
you were gonna make it
example.
like a group home or something, or-
Yes.
yeah.
So that maybe that's an example.
I would have to find out about that one, because that's, you know, on the edge, right? If that would be with, because those people are gonna rent too. And so it seems like that would still be a rental. And that's, yeah, I mean, again, withdrawal of the property from the rental market, the only way you're gonna get in trouble is when your ex-tenant finds out that you're renting it out again and comes back and says, whoa, you kicked me out to rent it out to someone else for more money? Ooh. Okay. Okay, be the owner compliant. Oh, and if the owner has to comply, obviously with a government order or a local ordinance that requires them to vacate. Or if it's determined by a government agency or court that the tenant is at fault for the condition or conditions triggering the order or need to vacate. So yeah, obviously, if you go to court for anything and a court or the government finds that they have to leave, you can terminate their tenancy. Okay, intention to demolish or substantially remodel. Substantially remodel. I've had this question a lot. And it has to be a substantial remodel. It has a definition, means the replacement or substantial modification of structural, electrical, plumbing, or mechanical systems that requires a permit, okay? And can't be reasonably accomplished in a safe manner with the tenant in place. Okay, and that requires the tenant to vacate for at least 30 days. So you see, this has to be some pretty extensive work. Anything that can be done in less than 30 days with the tenant in place, or less than 30 days at all, you're gonna have to put the tenant up. So you cannot evict a tenant to demolish unless you have, you know, this a big project. And of course, you'll never remember this, so we'll go back and read it when that comes up. Okay, before an owner of residential real property issues a notice to terminate a tenancy for just cause that is curable, a curable lease violation, the owner shall first give notice of the violation with an opportunity to cure. That's a 3-day notice usually, and you'll send a 3-day notice to let the landlord in the property to inspect, or a 3-day notice to remove the extra cars or the extra person or whatever it is that's on the property. Because if it can be fixed in 3 days, you have to give them notice. Okay. For a tenancy for which just cause is required, if an owner of residential property issues a termination notice based on no fault just cause, one of those ones we just did, the owner shall, regardless of the tenant's income, at the owner's option, do one of the following. Assist the tenant to relocate by providing a direct payment to the tenant, waive in writing the payment of rent for the final month of the tenancy. So you either have to give them the money, and you have to give it to them pretty quickly. We'll probably get to that. Oh yeah, within 15 calendar days of serving the notice, right? Or you can just send them a notice saying, I'll waive your last month's rent.
Cindy, this is for the city of Los Angeles or the
No, this
county?
is the whole state of California. City of Los Angeles and the county, they are probably have more stricter rules, and they don't even apply to this. But this is for all of California, unless you're exempt. And again, we're going to get to that, but single family residents are exempt if they've sent the notice. They don't apply, none of this applies to them. They don't need cause to get rid of a tenant. You have a month-to-month tenant, you don't want them anymore in your house, and you've given the right notice, you can just evict them. So I mean, you have to give them notice, but you can just evict them. Okay.
Cindy,
Yeah.
question. What if you have tenants in there prior to 2020?
So what they did when they first came out with the law is they said, if you send them this notice, if you send them the notice, I think it was by August 1st of 2020. If you send them this notice by August 1st of 2020, they will be exempt. If you didn't, after that, you have to have it signed.
Okay.
And there is some language in here about when you're supposed to have it done, but I think you couldn't bring an unlawful detainer unless you fell under these rules, unless you had that paper signed. So they're going to ask for it when you try to evict a tenant, or if the tenant complains about the raising of the rent.
So you have to have all of this with the box checked and then signed by the tenant?
Correct. Correct. And
Okay.
now, right, it has to be signed by the tenant because now it comes out with the lease. So it would get normal, and it does. Every time someone asks me a question, they send me the lease and they're always signed, but the box isn't checked because you
I
get to
see.
the end of the lease and you think you're done. You know,
Yeah.
none of the other ones really require the come out with it, require anything. And I think honestly, I don't
If
know.
you, Cindy, if
I
you
think
don't
they
have
did
a
it on
lease,
purpose so people would miss it.
yeah, if there is no lease and it is month to month, do they still need to sign this?
If you want to be exempt from
You
the
have to.
Tenant Protection Act. Yeah.
Okay.
Doesn't have
Okay.
to be written. I mean, you're just not exempt if you haven't given them notice that you're exempt.
Okay. Thank you.
Okay. Purpose to be credited. Okay, so the relocation assistance or rent waiver required by the subdivision shall be credited against any other relocation assistance required by any other law. So this morning, for someone, I researched relocation assistance in the city of LA. And for a qualified tenant, someone over 62 or handicapped or whatever, with some sort of a disability, it's $22,900, the relocation assistance. And see, this says this assistance shall be in addition to credit. Wait a minute, a rent waiver. Oh, a rent waiver required by this shall be credited. Oh, shall be credited. So if you did this, you don't have to do you can do 1 month's rent. But yeah, there's some stuff in the city of LA. It's pretty expensive. Like, well, it's even for a non-qual, just any tenant, it's $12,500. And for each tenant in the unit, you have to pay. So the one they
Wow.
talked to me about this morning, they only have 1 tenant. But if you have a whole family, it gets to be a problem. Okay. Residential real properties. Okay, so this does not apply. This whole thing we've talked about so far does not apply. Okay. To transient and tourist hotels, you're not probably selling any of those. Housing accommodations and nonprofit hospital, etc. No. Dormitories, no. Housing accommodations in which tenant shares bathroom or kitchen facilities with the owner who maintains their principal residence. So if you rent out a room in your house, you are not subject to this law. Single family owner occupied residences. Okay, single family owner occupied residences, including a residence in which the owner rents or leases no more than 2 units or bedrooms. What's the difference? Oh, that's one I just said. Oh, sorry. No, what's the difference between that one and that one? I guess the first one doesn't have to be a single family residence. It could be an apartment or anything. Or a duplex. Okay. Residence owner occupied residence no more than 2 bedrooms. No. Okay. So single family owner occupied residences, even if you have 2 tenants, are exempt from this law. Okay. As are duplexes in which the owner occupies one of the units. So if you're sharing a duplex, you also are not subject. Again, you always have to give that notice. Housing that has been issued a certificate of occupancy within the last 15 years. So anything built in the last 15 years is not subject to the Tenant Protection Act. Okay, so if you have a newer building or a newer house or a newer anything, residential real property that is, this is the one we go under, residential real property that is alienable separate from title to any other dwelling unit. So that's really a single family or a condo, right? Because you can sell it separate from any other unit. And the owner is not a real estate trust, a corporation, or a limited liability company where at least one member is a corporation. To get around the corporation, you couldn't do a limited liability company and make yourself the member. So if you have any of these, they consider that to be more not personal, not for someone who's living there, and they are never if you have these, then they're exempt. Okay, the tenants have been provided written note. Okay, so that was A. This is B. The tenants have been provided written notice that the residential property is exempt from this section. And they put, see this is the statement you have to put, which is in our notice. They put it right here, the whole thing. This is all part of the notice. Okay. Okay, a residential real property shall not be subject to both a local ordinance requiring just cause for termination of a residential tenancy and this section. Okay, so if the local ordinance is stricter, you're going to have that. So you wouldn't really have this in the city of LA right now because I think the local ordinance is stricter. I'm not sure about the county yet. So it just, you can't have both. So somebody's not stuck with two of them. Okay. So if it's less protective than this section, it's not going to be enforced. But if it's more protective, then it will be enforced. The local. Any waiver of the rights under the section shall be void as contrary to public policy. See that? You cannot waive your rights. So no matter how many times you have that tenant sign something, it can't be waived. Owner tenancy, we don't need those. Okay. This section shall remain in effect only till January 1st, 2030. So they put a sunset provision, I guess that's called, on this law. I don't know why exactly, to see, I guess, where we are in 2030. I mean, it's not like they couldn't change it anytime or get rid of it anytime or extend it. I mean, right? I mean, it doesn't, I don't know, but okay. Just, okay. Okay, so now we're into rent control. Okay, we're done with just cause. Anybody have any questions on just cause eviction? Okay.
I have a question.
All
Yes.
of the above.
Yeah, really. The 3-day notice, is that in our car form?
It is both a 30-day, 60, they're all there. I think.
Thank you.
If not, we'll find one if you need one, but I think there are.
They're there.
I've done a lot of 30 and 60s, but I don't think I've ever done a 3-day. I know, I think I just did one. Okay,
I have a question.
yeah,
So go back to, one of the, no cause that owner moved into the property. And how
one
long,
of the reasons you can evict for no cause, okay.
so how long the owner has to stay there in order to be legally?
Oh, it's a long time.
like
I
what,
don't know right off, but I bet you it's 2 to 5 years.
2 to 5 years?
I'll have to look it up, but it's not going to be short. If you're going to kick a tenant out, they're going to require, do you know what it is, Terry?
I believe that it's 2 of 5 years. I think it's 2 of the 5
2
years.
of 5, is that why I remember those two numbers?
Yeah, that's why you remember those numbers.
Yeah, 2 of the next 5.
Okay.
Okay,
You probably just need to have them do it right off the bat, because if they
Yeah.
do anything else, an irate tenant is gonna turn them in.
I was not subject to rent limits. Oh, oops, where's my rental start? Okay. Okay, we're right here. Okay, subject to an owner of residential real property shall not, over the course of any 12-month period, increase the rent for a dwelling unit more than 5% plus the percentage change in the cost of living, not more than 10, which we're usually at 10. Whichever is lower of the lowest gross rental rate charged for that dwelling or unit at any time during the 12 months prior to the effective date of the increase. So if you, we're going to get to this, but somewhere down here it says that you can increase it twice a year. You can do that 10% increase in 2 times, no more than 2 times. So you could do 5 and 5 or 6 and 4 or whatever you want to do, no more than 10 total. So that's why they talk about no more than 10 from the lowest it's been in 12 months, because you can't increase it like in 6 months and then say, oh, now I get another 10%. So, so every 12 months you can only do 10%, and you can only do it in increments of twice a year. Yeah, here it is. The gross rental for the unit for residential shall not be increased in more than 2 increments over that 12-month period. For a new tenancy in which no tenant from the prior tenancy remains in possession, lawful possession of the property, the owner may establish the initial rental rate not subject to subdivision A. Subdivision A is only applicable to subsequent increases after the rate has been established. So a tenant moves out, you can charge whatever you want to a brand new tenant that doesn't include anybody who was there before. And it says a tenant can't enter into a sublease that results in a total rent for the premises that exceeds the allowable rent as set forth. So a tenant can't have a subtenant and increase their rent more than the 10%. It works with the major tenant and the tenant if they have somebody living there. Okay. Okay, doesn't apply to housing restricted by deed, dormitories, housing subject to rent or price control through a public entity's exercise of its police power. Yikes. Housing that has been issued a certificate of occupancy within the previous 15 years. So if your property is less than 15 years old, you're not subject to this law. It'd be just like being a single family residence that check the box. Even if it's a duplex and you don't live there, or a triplex. Residential real property that is alienable, separate from title to any other dwelling. So again, this is the same thing. You're exempt if you're a single family house that isn't owned by one of these people and the tenant has been provided with notice. Then you're also exempt from the rent cap. Okay, so if you have a single family residence and you have given the notice, you have no rent cap. Okay, you just don't. This is only for people who come under the law, or properties that come under the law. Okay, then it gives you the whole rent cap thing all over again. So that's pretty much, I think that's it. So that is, it's not, I feel like it's complicated when you're hearing it for the first time, but it's really not as complicated as I think it sounds. I mean, it's very clear that you can have this reason or this reason, and you have to do these things. But the biggest thing you can do for any tenant you have, any client you have that is a landlord, they don't call them landlords anymore, they call them property owners or something like that. Anyone who's a landlord, make sure that they have that form with the box check signed by their tenant. And maybe if they're doing an increase or extending a lease, then that's when you get it. But let's try to get those. That's our best advice to landlords, because if they don't have it, then they can't, the rent control and they just cause and all that. Otherwise, there's nothing. If you have a month-to-month lease and you are exempt, you can terminate it because they have a month-to-month lease. Or the end of a fixed term lease, you can terminate the lease because it terminates automatically. So does anyone have any questions? It's not something you need to memorize. If you have a question, you've heard it now, you can always call and say, hey, I know we talked about this. How did this come out? What was this? What was that? The idea is that you're aware that it's out there. So if you need to know it, you know where to look and who to ask.
It's Jess. Where do you get copies of this?
Well, I'm going to send this out with this in the weekly, whatever the thing is,
Okay.
in the email, but it's on, I got it from the, I just Googled Tenant Protection Act.
Oh, okay. Got it.
Yeah.
Cindy, quick question.
Yeah.
So typical leases, are, I imagine 1 year. After the 1 year, and if you don't re-sign a new one, it's automatically defaults to a month-to-month rent, correct?
Right. If you accept rent. Yeah.
When it's month-to-month, basically you give them 30 days and you can get them out.
Some leases will say that at the end of the lease, it will go month to month, but under all the terms of the lease. So if I think that's what most leases would say, is that, just because it goes month to month doesn't mean you lose all the whole agreement you had.
Right, but you don't have to give, when it goes to month to month, you don't have to give a reason to evict them, right?
Well,
Gotcha.
if you're not subject to the law, to the Tenant Protection Act, you do not have to give a reason. Correct. But if you are, then you have to give one of the reasons that we just went over.
Okay.
Yeah.
And the only way, Cindy, just to confirm, the only way that the tenant is not subject to this law, the landlord is not, is that if they have already signed this and checked the box.
Correct. The box
Right,
was
okay.
checked and the tenant signed it. Right.
Signed it,
Yeah.
okay. And is it still, if they are there more than 2 years, 60-day notice, and under a year or up to a year is 30-day notice? Is that still
For
in effect?
outside of, is that right? I don't even know.
Yes, up to a year is 30-day notice. Anything over a year is 60, even if it's
60.
a year and 1 day.
And
Okay.
you'll notice all this stuff we just went over, if the tenant hasn't lived there 12 months or more, they're not subject to the law either. If
Yeah.
you have a tenant that's only been there 6 months, there's no Tenant Protection Act, even if it's an apartment.
Okay, good to know, yeah.
So yeah, but most people aren't having that under 12-month problem.
That's
So,
true.
Cindy,
Yeah.
on that question I asked you earlier, the tenant who had dogs got rid of the dogs because they were not supposed to be there, and now the dogs are there, even though it was a year ago when he was told to get rid of the dogs.
Is it in the lease?
Yeah, I have to find out.
If it's
No,
in the,
in the lease, it said no dogs.
yeah, if it's in the lease, it doesn't matter what he was told. It's in the lease. Yeah.
he can
And
be
so he
evicted.
brought the dogs back, right? He has them again.
Yes,
Yes, now, and during COVID, you couldn't evict people because they brought in a pet or another person, but now you can. It's not protected anymore.
yeah, doesn't
So-
matter.
If all the tenants are month to month and you want to completely renovate the building, the apartment building, then you don't have to pay them a relocation fee then, right?
No, because if you have an apartment building, then you probably are subject to the act. The act exempts only single family residences. So if you have a triplex or a fourplex or anything bigger than that for sure, then you're going to be subject to the act. There is no exemption for multifamily units,
Okay.
except for those other ones if there's a government thing or something weird. But yeah. Okay, so when you need it, you know who to come to. I have it saved on the top of my computer and was one of my favorite spots.
Thank you, Cindy.
Thank you.
Okay, someday I'm gonna figure out LA County and city, but I don't know when.
Oh, good luck.
I'm working on it.
They're all different.
I did a bunch of research on the city today. Now someone asked me a county question, so I got to do that too. So okay, well, thank you all. It was interesting, right?
Yeah, thank
Mhm.
you.
All right,
Thank you, Cindy.
Always
I've
interesting,
Always good
Cindy.
information.
had these are my most
You
interesting
have
days of my life.
encouraged me to move all of my rentals out of the state.
For sure out of LA County.
Yeah.